Next, we have with us Beth Santilli, attorney here at Mount Pleasant.
Asked Beth to come and do a class for us on breach of contract, which I think is something that interests all of us, obviously. Look at all who's here. So, Beth, I'm going to turn it over to you.
Thank you so much. Thank you, everyone, for having me back again. It's always a pleasure, and I'm so glad that so many of you turned out today. I thought for a while about how I was going to present this, and, you know, we've all been through contract seminars where we learn what a contract is and what a breach is, and that can get kind of dull. So I decided that I would take us through cases that have happened specifically to agents. And sometimes the outcome might not be exactly what you would expect. But I have about 10 cases that we'll talk about. And you can see the different types of law and what can happen when there's a breach of contract. Just to set the groundwork, a breach of contract occurs when there's a contract between two parties and one party doesn't perform. And then it's up to the court to decide if that party truly didn't perform or that party had an excuse for not performing. And hopefully you can work it out before it gets to the courts and lawyers get involved and fees get involved. But these are going to be examples of what can happen when it ends up at the court. So let's talk about this. This is Morrow v. Lewis, and this is in the Court of Appeals of South Carolina. You have a realtor and an owner entered into an exclusive right to sell real estate. The realtor attempted to sell the owner's property to no avail. Ultimately, the owner sold the property. Now, this is important. But the realtor maintained that the owner breached the real estate agreement even though he sold his property after the contract expired. So what's happened here is there's a contract between an agent and a seller, and that contract has expired. But the seller turns around and sells the property. The realtor maintained that after the owner breached the real estate agreement, even though he sold his property after the contract expired, the owner admitted that he breached the contract by being in contact with the ultimate purchaser of the property. So what's happening here is we have a seller who's negotiating with someone while the listing agreement is still active, but they don't execute their contract until after the listing agreement expires. So on appeal, the court found the sufficient evidence to survive the directed verdict motion on the breach of contract action because entering into a contract with the purchaser of the property could have been construed as breaching the conditions of the exclusive listing agreement. What does that mean? It means that the seller made a motion to say, look, I did exactly what I was supposed to do. I waited until this listing agreement ended, and then I entered into a contract with the buyer. And because of that, you should dismiss this case. And the court said, no, we think there's a little bit more to it, and that a jury could have found that the owner hid his negotiations from the realtor, and he had hid his actions in an attempt to evade payment of the broker's commission, which is exactly what happened here, and that's how the court ruled. Now let's talk about breach of contract for a minute. In an action for a breach of contract, the burden is on the plaintiff, so whoever brings the lawsuit has to prove the breach. And then damages is when the defendant is liable for whatever damages follow as a natural consequence and approximate result of such breach. So in this example, the damages would have been the commission to the agent. And the purposes of the word of damages is to put you back into the place where you would have originally been. I get asked this all the time. People say, what about my pain and suffering? I was really stressed out during all this. What about my attorney's fees? Pain and suffering you're not going to get in a breach of contract. You're only going to get what you would have gotten had the contract been successful. Attorney's fees, you only get attorney's fees two ways. You get attorney's fees because it's in a statute and a statute has been broken, or you get attorney's fees because it's in the contract itself. Sometimes your contracts will read, if we have to go to court because of this, the prevailing party will be awarded attorney's fees. So those are really the only two times you get attorney's fees. Now, in this situation, not only did the agent say that there was a breach of contract, but the agent said that there was a breach of contract accompanied by a fraudulent act. So what that means is you didn't only break the contract, but you intentionally set out to defraud me. You intentionally set out to get this purchaser to buy once my listing agreement expired. That's a difference in damages. Remember, breach of contract is only going to pay that agent's commission, but this accompanied by a fraudulent act, it's up to a jury to decide what the damages might be. There's three things that you have to prove for breach of contract accompanied by a fraudulent act. First, the contract was breached. We've done that. The breach was accomplished with fraudulent intention, and the breach was accomplished by a fraudulent act. So in this case, the seller had the intention to do what she did, and then she went ahead and she did it. So damages. Probably your question would be, well, what did the jury award? Well, guess what? 99.9% of all cases don't go to jury, and they don't go to trial. They get settled. So what happened here when it went to the Court of Appeals, and the Court of Appeals sent it back down to the trial court to have a full jury trial, the lawyers got together and negotiated this. All right, let's talk about Darby and Furman.
I have a question.
Oh, of course, asking questions.
On the previous case, you said that the person should prove that that act happened. So how, in that particular case, I'm the listing agent, how would I have enough proof to know that they engaged in this before the end of the contract? I would have to get into their emails and stuff like that and see some fraudulent act. In this particular case, who knows how they knew? And how did they prove it? That's a very good question. Two answers to that. First of all, some of the facts, I didn't put in all facts of the cases, but in this fact of this case, the seller had told the agent that she was talking to a few people and that she knew a few people that might be interested. And the agent said, well, you need to list those people for me. And this person never listed the people out. So what I assume happened is they get into depositions, and you're taken under oath when you're in the deposition, and the attorney starts asking questions of the seller about who are these people that you knew. This person comes up, and it ends up being one of the ones buying it. But you do have to prove, and you prove your case through discovery first. That's once you're in a lawsuit, you can request all kinds of documents. Like you said, emails, any kind of business procedures. You ask for depositions where you come in and you question people and you put them on the record. And then from that, you build your case. But it's fact-driven, and it's different with every single case. And if you have any questions for me, hey, just speak right up. I enjoy it. Let's talk about Darby. This is the seller brought an action for breach of fiduciary duty claim against the real estate company. Her claim was dismissed. Her writ was granted to determine whether, this is the issue, whether the real estate broker was allowed to retain a sales commissioner when he became the purchaser of the property. In reversing the decision, the court held that becoming a member of the entity, so he became a member of the LLC who bought the property, with an outstanding offer to purchase the property of its principal, the real estate broker abandoned his position as an agent to sell and became a purchaser of the property. Petitioner and broker had a written agency agreement. So we have an agreement, I'm your broker. I find out that Beth Santilli Law LLC is going to buy your piece of property. All of a sudden I become part of Beth Santilli Law LLC. We buy the property. I still want my commission. Here's what the court said. The court said in order to claim the commission, the broker and responding company were required to produce a written agreement signed by petitioner acknowledging the broker as a member of the entity with an outstanding offer to purchase the property and recognizing petitioner's rights to choose not to pay for the commission. The broker's oral explanations disclosing his position were insufficient to secure the commission. So in this case, the broker told the person,
I'm going to be part of this LLC that is purchasing your property. But the court said that wasn't enough, that they would have had to have had a written agreement.
Beth, if I could just add in there, and I'm sure y'all know this, we've talked about it this year. South Carolina licensed real estate license law states that, exactly that. You must have a written agreement letting that seller know they do not owe a commission.
That you don't owe the commission, or you have this breach of fiduciary duty. A couple things about fiduciary duty is these are things that can get you into trouble. Just so you, and I'm sure that you already know this, but real estate agents occupy a fiduciary relationship with their clients and are under a legal obligation as well as a high moral duty. And all these words come directly from the court. So they're saying a high moral duty to give loyal service to the principal. We're going to talk about disclosure a few times today, but in this example, the duty of an agent to make full disclosure to his principal of all material facts relevant to the agency is fundamental to the fiduciary relationship of principal and agent. It becomes a little fuzzy when you're not, so let's say that you're the buyer's agent. What type of duties do you owe the seller, or do you owe the seller any duties? And we're going to talk about a couple of those cases in a while. Now, this is straight from the statute. No broker or salesman shall either directly or indirectly buy for himself or a corporation or any other business in which he holds an interest for a close relative. Property, that's important. A close relative. So just because maybe your wife is buying it or your husband's buying it, you're still going to get yourself into trouble. Property listed with him or property for which he's been approached by the seller or prospective buyer to act as broker without first making his true position clearly known to all parties involved, and that's why you have to. Let's talk about Ackerman. In Ackerman, the parties entered into the contract for a sale of real estate. The sellers, this is an important part, the sellers changed their mind about moving and the closing did not take place. The buyer brought a breach of contract action against the seller. The trial court held that the buyer was the breaching party because she had failed to apply for financing during the period stipulated. So the seller files a suit for breach of contract, and the buyer turns around and says, oh no, you couldn't get financing. I still wanted to go through with the deal, you didn't. On appeal, the court reversed and remanded, holding that the buyer's failure to apply for financing during the stipulated period was not the reason the sellers withdrew from the contract. Her breach did not justify repudiation of the contract. We'll talk about repudiation in just a minute. Because the buyer obtains the funds with which the contract was not defeated, the seller's only recourse was to seek damages from the buyer, if any, and not to repudiate the contract, which is what they wanted to do because they didn't want to move. So their whole goal in this lawsuit was to try to stay in their house. So instead of going through closing, they said, oh, we're not, we don't want to close. We don't want to close because you didn't get financing. When really the true reason was that they didn't want to move. Now, what's repudiation? It's a fundamental breach of contract. It's so fundamental that it permits the distressed party to terminate performance of the contract, plus sue for damages. So what was important here is we're saying we're getting rid of the contract totally. Not only am I going to sue you for damages, but I'm not going to go through with the contract. It must be so fundamental and substantial as to defeat the entire purpose of the contract. But in this case, buyer's failure to apply for financing within 10 days was not the reason the sellers withdrew from the contract, so it could not be repudiated.
So if they couldn't get financing, then they couldn't buy the house anyway.
She did get financing. She just didn't do it within 10 days. Right. So it was supposed to be a 10-day, but she had tried to get the 10 days, and then, well, they were in, another thing about the facts of the case, they were in hot and heavy negotiations going back and forth. They weren't completely set on the price. They weren't completely set on everything. So there was reasons why she didn't get this financing within 10 days. But she did get it, and the court upheld the contract. How long did that take?
I'm just curious how long, because I imagine it'd be a long period of time.
It is a long period of time. Well, let's put it this way. I couldn't tell you the exact time when it started. What do you guys, yes, I can.
Because that's one of the factors we talked to our clients about. You know, if you really want to do this, it's going to take you 6 months, a year, whatever.
Okay, the case was heard in the Court of Appeals in March 21st, 1994, which seems like a long time ago, but in law standards, that's like yes. Now, it started, though, in 1989.
So she stayed in the house for 6 more years before she had to get kicked out of the house.
And so they're fighting this whole time.
The damages add up over 5 years.
And the damages do add up over that time. And again, they ended up settling, so who knows how much they paid for it. But you're right, damages continue to add up. But anything in law takes such a long time. And it's not only financially draining, it's emotionally draining. And that's what I tell all my clients before. Sometimes you have to litigate, there's no way around it. But you try to do everything in your power to settle first, because it's better for both parties in the end. Sometimes you just can't come to an agreement.
Are there limits on how long they could wait before they want to take action?
Yes, that's called a statute of limitations, and it's 3 years for, it's not always 3 years, some are 2, but generally speaking, it's 3 years from the date the incident was discovered. So let's say I buy a house and there are all kinds of latent defects to it that I don't know. I have 3 years from once I discover what those defects are to file a lawsuit.
Okay.
Yes, sir.
Isn't the first step in a disagreement between parties mediation?
That's a good question. It is, in the state of South Carolina, you have to perform mediation. So even if you file a lawsuit, so this, well, first of all, usually what happens, 2 lawyers get together and they try to work it out. They can't work it out. Then somebody files a lawsuit. Then in that lawsuit, you have to sign up for mediation. And usually within the first year, it usually happens after discovery, but usually within the first year, you have to have some form of mediation. And hopefully you can settle at that point.
You mentioned the difference of 2 years and 3 years. Some things are 2 and some are 3. Without going into a lot of details, can you just roughly say what would be a 2-year limit and a 3-year limit?
Defamation's 2 years. So defamation, slander, libel, 2 years. 3 years, almost everything else, breach of contract, just about everything's 3 years, unless by statute, the statute of limitation is less than 3 years, or if you're suing the government, and I can't remember if that is a year or 2 years, I'd have to look at the law, but that's all by statute.
But pretty much most of what we would deal with would be 3 years.
3 years, yes. What happened here? Chastain. The buyers argued that the trial court erred in granting summary judgment to the realtor because the realtor owed the buyers a duty of reasonable care and disclosure. And a lot of these cases are about disclosures with real estate agents. And because questions of facts remained as to what the realtor knew or should have known about flooding history of the home which the buyers purchased from the sellers. The argument was without merit because the buyers made no show of prejudice. You always have to show that you've been damaged, by the way. Even if you have a really good case on your hands and someone has been an absolute jerk to you, if you can't show damages, you still don't have a case. But the next thing I think is more important to everyone here. As to the merits of the buyer's negligence claim, the court found that to the extent that the realtor, as a real estate licensee, owed the buyers a legal duty, this duty did not include investigating the accuracy of statements made by the sellers on a disclosure. Moreover, the buyers presented no evidence that the realtor had actual or constructive knowledge that the statements on the disclosure were inaccurate or incomplete. So in this case, you had someone who was in a floodplain, and there had been flood damage, and they disclosed it, they half disclosed it. I mean, they didn't completely say that we're not in a floodplain or that we've never had any flooding, but they really minimized the problem. and the agent did nothing to go back to make sure that that disclosure was correct. And what the court's saying is the agent had no duty to do so. So,
Along those lines, of course, if the agent knew that the house had flooded, then the agent would have an obligation to tell that.
and if not, they would be held accountable for fraud, which we're going to see another case where they were not.
So
Yes,
then
sir.
the purchaser would have to go against the seller for damages should they want to, and the agents, I just showed you the paperwork.
The agent was definitely off the hook because they didn't have a duty to inspect, and they had no constructive knowledge that this flood issue was occurring in this home. But like Liz said, the facts would be totally different if the agent knew. Then the agent could be held for a breach of duty to care to inspect or investigate. Yes, sir.
But another way to cover ourselves would be to suggest that they get flood insurance quote, because the flood insurance company would have an elevation accuracy map that they could say, yes, you are in a flood zone. Would that help cover our case even more?
Well, the buyers are always under their own duty to inspect, okay? That's why they get an inspection, that's why they do what they need to do. I don't think that it hurts ever to make the recommendation that you seek, an expert opinion, but the important thing to remember here is that you as a realtor don't have to go above and beyond what the seller has told the buyer about the status of the house.
I'm just getting back to the flood stuff because
I think it's all.
I know that these certain neighborhoods get flooded, so there would be an assumption a lot of times that, yes, I would think that that's a flood zone, but it didn't say flood zone on the disclosure, and so I'm sitting here going,
it certainly couldn't hurt.
yeah, so I was like, yeah, don't get flood insurance, quote,
I see what
have
you
your
mean.
flood expert decide what zone.
Especially, well, in that case, like you said, you could be construed as having constructive knowledge because maybe you know that neighborhood has a problem with floods.
That are, so
Exactly, so
assume
to cover yourself would be good.
Is there any responsibility from the insurance companies that they're getting a policy from to notify them that they're at risk in a flood area?
I don't know the answer to that. I don't know if they have if the insurance carrier has a duty to disclose that that they're in a flood zone or not.
Well, the lender won't lend money if they know it's in a flood zone and they don't have flood insurance.
If they don't, so, you have a lot of checks and balances of other people who are interested parties who could bring it up. It just happens in this case, it didn't happen, that they were able to slide in this non-disclosure that wasn't completely truthful. And in this case, the agent was not held accountable, but the seller was. Here's what the law says. A real estate licensee is not obligated to discover latent defects in property or to advise the agent's clients on matters outside of the scope of the agent's real estate expertise, and that's by statute. Additionally, you're not liable to a purchaser if the owner provides the purchaser with a disclosure that contains false, incomplete, or misleading information, and that's important, this is an and the real estate licensee did not know or have reasonable cause to suspect the information was false, incomplete, or misleading. So that's the important thing. You can't have any idea that was misleading.
What if your client asked you a direct question, and so you maybe call the other agent, you do what you can to maybe find information, maybe you go, I don't know we should do this, but we go talk to a couple of neighbors. Is that something we should be doing, or can we do, or is that putting us out there on the line? Because we're going to come back and say, well, this is what I did.
Well, I think the investigation is good, especially if your client is asking you, although you always want to pull in an expert if there's a question, because you can't really talk to that if you're not a flood expert, or you're not, whatever the defect might be.
Right.
Probably the best thing is to call an inspector who knows that area of the law.
Okay.
All right, good old Slack versus James, and this is in the Supreme The sellers and buyers, each represented by real estate agents, entered into a written contract for the seller's home. The buyers hired an attorney to represent them during the closing. In conducting a title examination of the property, the title examiner informed the buyer's attorney that there was a permanent 4-inch sewer easement across the property. After this discovery, the buyers refused to purchase the property because prior to entering into the written contract, the buyers had asked the seller's real estate agent whether there were any easements on the property, and the agent informed them that there were none. The state Supreme Court found that the appellate court properly concluded that whether the buyer's reliance on the seller's agent's alleged misrepresentation was reasonable was a question of fact for the jury. Further, the appellate court properly concluded that the merger clause set out in a paragraph of the purchase contract could not be used as defense by the sellers against the buyers tort actions of fraud and negligent representation. All right, so this is a little bit different. The agent told the buyer that there was no easement, that everything was fine. And then the attorney gets involved, and the attorney does a title search or hires somebody to do a title search, and they find out that there is this sewer easement. And the buyer says, hey, agent, you told me there wasn't an easement. I want out of this contract. And by the way, not only do I want out of this contract, I'm accusing you of fraud and negligent misrepresentation. Let's talk about merger and non-reliance clauses. The buyers are suing the real estate agent.
There were just two agents. The buyer's agents. The buyer's agent.
Sorry, yes. Buyers
are suing the seller's agent.
Buyers are suing the seller's agent.
Oh, okay.
My first question is, why would the seller's agent be talking to my buyers?
So maybe they shouldn't be talking. Well, and if they are, they're telling them that there's no easement there, and there is an easement there, and
So was the buyer's agent sued also?
Well, it said the
What was the buyer's
agent told them. Yeah,
the agent.
The listing agent,
The agent
yes.
told
But
them.
I was told the buyer's agent got sued as well.
That I don't know.
Yeah, just curious.
At least not in this. I mean, they might have been sued early on and released and settled or something. But by the time it got to the Supreme Court, it was only the buyer and the seller's agent. Now, here was the argument. The argument was in the contract that the seller signed. There was something called a merger clause. And I know when you read these contracts, you see all that boilerplate information, and it can just roll right over. But every single one of those phrases actually means something, and it's put in there because of some kind of lawsuit along the way. Somebody decided that you were supposed to have that. So there's something called a merger clause, and a merger clause can act as a general reliance clause. So the merger clause was, what they were arguing was that this merger clause meant whatever I said outside of this contract didn't matter because this contract was only complete about what was on the written pages itself. It had nothing to do with what I said. The Supreme Court said, no, that's not right. You can't use a general merger clause. You have to have something called a non-reliance clause. So a non-reliance clause would have said something like, any statements that were made prior to the execution of this contract in no way impact the four corners of the contract. Okay, that's non-reliance. You have to use the words to rely or reliance. So because of that, the court said a couple things. First of all, they said, given the speedy nature of residential real estate contracts today, it's not feasible to expect a buyer to be able to research the title of a property they are buying before they enter into a contract. So that's the first thing they said. Then they said what I just talked about. Having a general non-reliance clause, just as a merger clause, does not prevent one from proceeding on tort theories of negligent representation and fraud. You have to have, if you have these non-reliance clauses, it has to say that I'm not relying on any statements prior to this contract itself. But notice at the bottom where I have, we've got a dissent by Chief Justice Toll. She says, I respectfully dissent. In my opinion, the sales contract buyer signed including a binding non-reliance clause. Therefore, I would reverse the Court of Appeals and uphold the trial court's dismissal of buyer's fraud and misrepresentation claims. What this means is our law is not clear. We have a case where the Supreme Court ruled that just because you have this general clause in your contract doesn't mean you can get away with fraud or misrepresentation claims. But we have Chief Justice Toll saying, yes, if you have that clause, it would stand up and it should stand up in a court of law. The best thing to do here is not talk to what you were saying, not say things that you're not sure of. How can you possibly know if an easement exists or not?
Well, that's the thing, you may not know if easements exist or don't exist, so you ask the seller or the listing agent, if they tell you the answers you want to hear, then your client goes forward and does write a contract.
Right.
So, is that between fraud and just the contract itself?
It's the difference between, we just talked about you don't have a duty to inspect latent defects that are outside your area of expertise.
Right.
But when you sign up and start saying things like, there's no easement here, now you've made a statement of fact.
Right.
So the best answer is, I'm not an expert in that, we need to get an expert to take a look at it.
Wouldn't a survey take care of a lot of that?
You would think so, but that's not my area of expertise. Maybe they, I don't know why they wouldn't have had a survey.
But that wouldn't be done before the contract.
Before the contract was.
And many people don't have it. Yeah, the problem here was that they relied on the contract because the person said there were no easements.
How funny for that to get brought up. Like maybe they not knew there was, but there was enough to where they asked that question for a reason.
Well, yeah, the buyers were concerned they didn't want to buy anything with an easement on it, so.
Yeah.
So why didn't they just get out of the contract and go on to the next one? Maybe they were just upset about it, they felt like they were defrauded or something?
Well, they might have lost other deals.
And some people just like.
Some people litigate.
One of them stating that there was no easement, that's pretty much what they did.
And they're saying that was negligent representation and fraud. And you get damages for that. I mean, that's beyond breach of contract. Breach of contract would be just whatever your money that you might have lost if the contract doesn't go through, but fraud or negligent misrepresentation, you're talking about the jury awarding damages. All right, let's talk about Harrington. Oh, this is interesting little case. A son requested that agents list his mother's house for sale. The son accepted the buyer's office to purchase the property by signing the offer with the indication that he was acting as his mother's power of attorney. Later, however, the son's attorney told the buyer that the son had discovered that he didn't actually have the power of attorney. The son then repudiated the contract. The court first noted that no fiduciary relationship existed between the buyer and the agent who represented the son. It rejected the buyer's argument that the agent had a duty to verify the information concerning the power of attorney. It stated that agents act as a mere conduit through which the son relayed information concerning his possession of a power of attorney. Although the issue of reliance was generally a question of fact for the jury, there was no evidence to conclude that the buyer's reliance was justifiable and that the buyer could have ascertained the information, and agents were not the buyer's agent. So this is what we talked about earlier today about where your fiduciary duty lies. But there's always something you want to be careful when you get these power of attorneys. And you want to make sure that they're recorded, and you want to make sure that they're in effect.
Where do we find out they're recorded?
At the RMC office, you can do a line right on, so you can do a search right online.
And that's a specific power of attorney for real estate, not general power of attorney, correct?
Oh, now here, in this one, this was a general power of attorney.
But you can't do real estate with that, correct? Even if you had.
No, he could do that with a general power of attorney. He could sell his mother's house.
So it doesn't have to be a specific power of attorney for the sale or purchase of.
No, it's not. As long as there's a caveat around that. As long as the power of attorney states that the attorney in fact can sell property.
Right.
It has to say it.
Specific to selling of a home, real estate.
But it could be any property that the person owns.
So what do you recommend there? Always check the power of attorney?
I'd always check the power of attorney.
Verify that?
Yeah, I'd always check the power of attorney. Just
Even
to make
though we
sure
don't
that
have to.
You don't have to, I just think that you should.
Okay.
Or just make sure that you have one that's valid.
The other thing along those same lines is, if you have trust, or these, lately I've seen a lot of trust in estates, sales or buyers, you need to verify, and on our contract, it has that paragraph that says that there's proof that the person who signed has the right to sign. And I think most agents are ignoring that, but you need to make sure that if you've got somebody signing a contract for an estate or trust, they have the right to do that.
And in fact, I just went through that. I had, it wasn't and it didn't turn into a lawsuit or anything, but, the person had been acting as trustee for the estate for several years, and she had been named successor trustee in the trust document. But the original trustee was actually the Bank of South Carolina, although the bank had never served in that capacity. It turned out to be fine, and we did the paperwork that we needed to do, and we made sure that she was appointed trustee. But what Liz is saying is very true. You need to make sure that the person who's signing on behalf of that trust or on behalf of that estate either is the personal representative who can sign on behalf of the estate or the trustee who can sign on behalf of the trust. Now, it's hard when you're talking about negligent misrepresentation, but these are the things that you need to prove, someone would have to prove against you in order to have negligent representation. A false statement, a monetary interest, there was a duty of care to be truthful, that the defendant breached that duty, that the plaintiff justifiably relied on the representation, and that the plaintiff suffered a monetary loss. So the reason that I put those up there, there's a lot of elements that have to be proven in order to show negligent misrepresentation, but it's a cause of action that we see a lot.
So you have to find all of those.
You have to find all of those, every single one of them. If you can't prove one of those elements, then there's no negligent misrepresentation. This is May versus Hopkinton. See, the case was first heard by a master who found the purchasers had established their cause of action. This is for fraud. By clear, cogent, and convincing evidence, the master found that the seller and the real estate agent had agreed among themselves to withhold from the purchasers the fact that there was severe moisture and termite damage to the house. The master awarded damages to the purchaser in the amount of $30,000 in actual damages and $60,000 in punitive damages. The seller and the real estate agent sought review by the court. They changed the judgment, but then on appeal, the court held that the facts found by the masters and the inferences that could be reasonably drawn from the established all the elements of fraud by the seller and the real estate agent, and the damages were brought back to the full amount. This is when there's that latent effect. We've already talked about that you don't have the duty to inspect, but this is the time when you know, and the homeowner who's selling the house knows, and you try to cover it up to sell the house.
Which none of y'all ever do.
No. And that's when you can get a judgment for fraud, and that's when you can have punitive damages, which could be very high.
And what if there was a defect in the home that was fixed? Does it have, where is that possible?
A defect in the home, it's no longer a defect?
No.
But it concerns you enough that you question it?
I'm asking.
I mean,
Saying that there's a defect in the home that has been repaired.
But it's not a defect today.
because it's not a defect today.
But it ends up being repaired wrong.
Oh, it ends up being repaired wrong.
I'm just saying that
Or it
That's not
ends
the
up,
same case, this is a different thing. But it's
Well,
different.
putting them on Liz law.
yeah.
You need to make your, sellers put that on the list. It's better to have it out in front rather than hide.
Then, because it comes very fact specific as to whether it was really fixed or it wasn't fixed, or it was just skimmed over so you could try to sell the house, so you're skating on thin ice. Better, like you said, your
Just
rule,
provide the
better
document showing that it was fixed also.
show them that it's fixed, disclose.
I think it's always better to disclose.
Yeah, it was a problem, but it's been fixed.
Yeah. Unconscionability. The last thing you want to talk about is unconscionability in a contract. Our contracts that we have, our buyers or our sellers sign, are contracts of adhesion. And a contract of adhesion means that they have no bargaining power. That they're signing it because if they don't sign it, then you're not going to do the work for them. So it's a take it or leave it kind of thing. Those types of contracts are not per se unconscionable, and you can use those types of contracts, although they're looked with disfavor in front of the court. So unconscionability. Sometimes someone will try to sue you saying that the contract was unconscionable. And the big thing to remember here, and then we'll end up, is that courts generally must enforce contracts that are freely entered into according to their terms. However, if a court finds that a contract clause was unconscionable at the time it was made, the court may refuse to enforce the contract clause or limit the application of the unconscionable clause to avoid any unconscionable results. So that's just something that you bring up. So what does that mean? That means if the last ditch effort that someone will put up there is that your contract was unconscionable, that no reasonable person would have entered into this contract when they entered into it, and because no reasonable person would enter into this contract, you should make it null and void.
And that's outstanding.
Thank you.